It's a medical malpractice case. The defense wants to dismiss our case. They ask the judge to dismiss it, claiming that our case doesn't have any merit. Why is it essential for us, then, to go ahead and hire a medical expert to come in to rebut the defense's arguments, claiming we have no valid case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now, during the course of the litigation, there is the good chance that the defense is going to turn around and say, listen, Oginski's client doesn't have a valid case. Here's why. And now they go ahead and hire their own medical expert to submit papers to the court to say, listen, I reviewed all these records. There's nothing here to say that this doctor violated the basic standards of medical care. This patient's injuries did not result from this doctor's treatment. So now, what happens if we don't oppose that? What will happen is the judge will look at it, see that there's no opposition, and say, okay, there's no opposition, Oginski's client agrees, case dismissed. Well, we can't do that. The only way we can start a case in New York for medical malpractice is if we have a qualified medical expert confirm that, number one, that there's wrongdoing, number two, the wrongdoing caused injury, and number three, that the injury is significant and or permanent. Only then can we go ahead and start a lawsuit. And during the course of the litigation, if the defense now turns around and says, hey, you don't have a valid meritorious case, we want your case dismissed, now we have to oppose the defense's request by putting in our own papers with our own medical expert, who basically says, listen, I've reviewed all these records, I've reviewed all the pretrial testimony, and it is my conclusions that there is a violation from the basic standard of medical care, and that there are violations from basic standards of medical care, and that those violations or departures were a direct result of and a direct cause of this patient's injuries. So now the court must look at both competing experts. One says there's no validity, the other one says yes, there is a valid case, and now what does he do? In all likelihood, he's going to turn around and say, listen, because there are competing experts who both say opposite things, I believe this is a question of fact to be decided by the jury. And now he'll let a jury decide ultimately when the case gets to trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in a medical malpractice case here in the state of New York. You know, I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.